to the Unofficial Signees, and today Damien, Grant and Brent Norling, we will be talking about Phoenix companies. So Brent, do you want to tell us what a Phoenix company is?
Yep, so a Phoenix company is a company that trades as a similar name to a failed company. So a failed company goes into liquidation, new company sets up, probably puts in 2019 in brackets or something similar. So ABC Builders Limited becomes ABC Builders 2019 Limited, and they continue to trade off into the sunset.
And those have been illegal for about 10 years now. So what had been happening is that company directors have been setting up, particularly developers, but not just developers. They've been setting up a company called Wynyard Developments, and they would keep setting up Wynyard Developments A, Wynyard Developments B, and so forth. And so the people who were trading with them, the tradies, the electricians, and all the rest of it, were finding that they weren't entirely too sure what business they were trading with. And so Parliament came along and said, hey, we're putting an end to that. What a Phoenix company isn't is if you have a company called Wynyard Developments and then you set up a brand new company called Hobson Bay Developments, the fact that Wynyard goes into developments, if you're the director of the new company, that's not a Phoenix company. It's only a Phoenix company if it has the same name. And that's covered under Section 386A of the Companies Act. So Brent, tell us about that.
Yeah, and I think that's an important point though, because that's what we see a lot of confusion on is can I set up a new company and trade? Because some people think a Phoenix company prohibits them, those rules prohibit them from setting up any company. So it really is just one with a similar name. So Section 386 really sets out the rules around who can, because there's more rules around who can actually operate a Phoenix company. So a Phoenix company, it's not just a company with a similar name, it's a company that has the director of the failed company that is taking part in the new company. And it's more than just being a director. So it's being involved in the management of it, the promotion of it, the setup of it. If the director of the failed company does those things in the new company, they're committing an offence.
Is it just the company name, or does it matter what the company trades as?
So yeah, it is. That's an important distinction. So it is also what the company trades as. So you could be called ABC Limited, but if you trade as Wynyard, then you're also in a bit of grief.
So you have ABC Limited trading as Wynyard Developments. You then liquidate that. You set up a new company called 2017 Limited. But that also trades as Wynyard Developments.
Yeah, that's
You're
a problem.
Saying that's also a Phoenix company.
That's a problem.
Right. Tricky. Okay.
Yeah.
All right. So I'll talk just a little bit about the process. So what happens when we do a Phoenix company? So what happens is the company director comes to us and they want to, so they've got a company, and often what happens is they've got historical debts, but the business is trading at a profit on a month-by-month basis. So we'll come along and we'll say, all right, what Section 386A says is that you can't be a director of Company A, have that go into liquidation, and then be the director of Company B with the same or similar name. But what the Companies Act says is that if you liquidate Company A and then you buy all of the assets off the old company, off the liquidator of the old company, and then you write to all of your creditors, if you do that, then you're not prosecuted under Section 386A. You get a free pass.
Yeah, so I mean that's the exception to it, right? All good laws have good exception.
Yep.
And so that successor company notice that's given to all of the creditors, that notice has a whole bunch of information just to make sure that they're fully informed that there is a new trading entity. They may need to update their trade terms, they may need to look at their situation, and if they choose to continue to trade with the new company, they do it on a fully informed basis.
So you're saying that if I'm a creditor of a company, that company goes into liquidation, I then receive the successor notice from the director, I now know that he's done a Phoenix company.
Yeah.
So if I continue to trade, I'm not being tricked as I may have been what was happening previously.
Well, because a little a director of a Phoenix company can be personally liable for all of the debts incurred by the Phoenix company if they don't comply with these provisions. And that's from a civil perspective, but I mean, there's if they breach these provisions, they could be liable for up to 5 years imprisonment or $200,000 fine, which I haven't seen passed down and unlikely to be passed down.
I don't think that's ever happened. I don't think anybody's even had to wear an ankle bracelet for breaching the Phoenix company.
Yeah,
most people are convicted and discharged.
Yeah.
So what's the rule? Let's say I've got two companies. I've got Wynyard Developments and Wynyard Developments New Zealand Limited, and they're both trading, and they've been both trading for a couple of years. And I put one of them into liquidation. What happens to the other one?
So the other one can continue to trade. And
so that one's not a Phoenix?
No. So another exception to those rules is, so if you have a company that's trading for at least 12 months prior to the failed company going into liquidation, then that's not a Phoenix company. It's not captured by the rules, and it can continue to trade.
So could I set up a company, just have it sitting on the books, not do anything, wait the 12 months, then liquidate my other?
No.
So what does the other company have to be doing?
It must be trading. So it must have some form of trading to qualify. It can't just be a shelf company.
So a monthly invoice to your lawyer, would that count as trading?
Yeah, maybe some management fees to the failed company. Who knows?
All right. So that's a quick snapshot on what Phoenix Company restructures are. We often see them used where you have a company that is now trading profitably but has historical debts, often tax debts, but not exclusively. A company that starts up, takes a year or two to get going, runs up some historical debt, it's now trading in the black, and they want to restructure. It's not a good idea, obviously, if you're continuing to trade in the red and you just want to burn some historical creditors. That's perhaps not what Phoenix Company is for.
Yeah, I mean, probably the best example that I've seen is a company that had entered into some commercial arrangements that were uneconomical, was going to lose about $10 million over a 6-year period as a result, and it really needed to restructure away from those arrangements because the rest of the business was completely viable. So this was a way in which it could restructure its affairs, continue to trade, continue to employ all of its staff, and avoid what would have been a complete failure.
So from a practical perspective, if I'm a company director and I want to go through the Phoenix Company process, do I need to put my company into liquidation and then hope to negotiate with the liquidator once he's in office, or can I do some negotiations in advance?
Yeah, absolutely. I mean, we would never advise a client to put it in the hands of the liquidators
Very wise.
Without some certainty. So my approach is to, we talk with the liquidator up front. We give them all the information that they need. They can do their due diligence. They can investigate it. You can discuss the arrangements and make sure everyone is on the same page before the company goes into liquidation, because if there's too much delay between the liquidation date and the sale of the business date, staff can leave, the customers can leave. I mean, it can be quite devastating. There might be no business.
So let's talk about a real life practical example. So what we're talking about here is pre-packs. So here we have a situation where you literally put a company, all of the negotiations happened with the liquidator leading up to the appointment, and then the liquidator signs the paperwork. The liquidator is given the liquidation and then does the Phoenix Company sale and purchase immediately afterwards. So can that happen?
Absolutely, yeah.
Yep. Yeah. Okay. I think that's enough from us from Phoenix Company restructures. Thanks for listening, and we'll have some new stuff for you next week.